Right, good evening and welcome to what is now the third in a series of annual talks that take place from international practitioners that's hosted by the Inner Temple. Last year we were very graciously hosted by the Temple Church. This year, for two reasons, we're back here. Firstly, we have these lovely new shiny facilities with the inns reopening in May 2022. And secondly, I made a rather off-colour joke about St. Peter meeting a lawyer at the gates of heaven. But anyway, I'm going to brush over that because it doesn't bear repetition. We're exceptionally lucky tonight to be entertained, enlightened, educated by a star-studded panel of speakers. And I'm delighted to welcome, on your behalf, Michael Gration, KC of 4 Paper Buildings, Joshua Kern of 9 BR Chambers, Naina Patel of Blackstone, Judy Fu of 3 Verulam Buildings, and Tom Weisselberg from Blackstone. The idea is that each speaker will speak about their practice area, their international practice area, for about 10 minutes or so, and then we'll have questions at the end. I do have some short housekeeping points. Firstly, this event is being recorded and will appear on the Inner Temple website in the coming week. A link will be sent to all guests afterwards. Can we therefore please ask that you turn your phones off so they're switched off on silent, and if you have watches that beep at you, please can you do the same with them? Students and those who require a qualifying session credit have to sign the sheet at the reception area before leaving, or you may not be given your credit. The session is not a qualifying session for non-Inner Temple students. If you're a practicing barrister, you can claim this for your CPD, and there will be an opportunity for those here in person as well as those attending online to ask questions of our panel. I also should have said, delighted to welcome those who are following this online. We have about 40 or so of you online and a healthy smattering here in person. Questions can be addressed to any individual panelist or the panel as a whole at the end of the session, but please do try and keep your question succinct because it will encourage a lengthier answer. There will be some refreshments at the end for those attending in person. For those online, you'll have to make your own arrangements. Can I then start, please, with a short introduction to our esteemed panel. Michael Gration, KC, is a barrister at 4PB. He was called to the bar by Inner Temple in 2007 and took silk last year. He specialises in cases involving the international movement of children and has appeared in most of the leading cases in the field of international family law, including on Hague and non-Hague abduction, jurisdictional disputes, the recognition and enforcement of orders, relocation, and public law cases with an international or other jurisdictional issue. He's represented parties in domestic courts and also before the ECHR and the Court of Justice in Luxembourg. Joshua Kern, immediately to his left, is a barrister at 9 Bedford Row and was called to the bar by Inner Temple in 2013. He was previously admitted as a solicitor, including in Hong Kong, I found out this evening. He's acted in landmark cases of historical and international importance, including the trial of the former Minister of the Khmer Rouge at the ECCC and Kenyatta's trial at the ICC. Josh is a member of the INS International Committee and also the American Bar Association's International Criminal Justice Standards Advisory Group. Naina Patel, to my right, is a barrister at Blackstone Chambers. She was called to the bar by Inner Temple in 2005. Her practice encompasses a broad range of admin and public law, civil liberties, human rights, commercial law, immigration, public international law, the rule of law, and sanctions. Naina advises governments, private sectors organisations, NGOs, and also works in the field of international development. She's worked on human rights, promoting development programs in Rwanda, Kosovo, Azerbaijan, and Afghanistan. And she is currently acting for Ukraine in the interstate case Ukraine and Russia concerning the Ukrainian government's allegations of human rights violations by the Russian Federation. Judy Fu, to my left, is a barrister at 3 Verulam Buildings. She was called to the bar in 2019 by Inner Temple, but had spent a long and prosperous career as a solicitor. She has a broad litigation practice, including in commercial, civil fraud and banking. Judy sits as an arbitrator, acting in disputes conducted under all of the major sets of arbitral rules, ad hoc arbitration under the UNCITRAL rules. As a native of Hong Kong, Judy has worked extensively in Asia and has experience of many jurisdictions, representing clients in courts as diverse as those in France, India, the Cayman Islands, and also in Luxembourg. Tom Weisselberg, KC, is our final speaker. He will be talking about Pegasus scholarships. He is joint head of chambers at Blackstone Chambers. Called to the bar in 1995, he took silk in 2014 and was elected as a governing bencher of the Inn in 2021. He's extensive litigation and advocacy experience, appearing in the Supreme Court, House of Lords, Privy Council, Court of Appeal, High Court and County Courts. He regularly appears in domestic and international commercial arbitrations. He too is on the International Committee, and that is a recurring theme of the speakers who are invited to attend these events because they have no choice. He's also the Pegasus on the Pegasus Scholarship Trust Board, which covers more than one inn. So I'm extremely happy to be able to welcome each of our guest speakers this evening to, as I say, go through their individual practice areas. There are 10 minutes. We'll start now with Michael. We are going to be quite strict on timing, so we have plenty of time for questions at the end from each of you. Thank you very much.
Thank you. Good evening to you all. When I started on my pupillage, I knew that I wanted to do family law, and I had obtained a pupillage at a family law set. I had no idea, because it wasn't covered at all at university or on what was then the BVC, that international family law existed as a topic area, and was just fortunate to arrive at one of, at that point in time, 3 chambers that specialised in international family law for my pupillage. Nonetheless, for the first 6 months, I didn't get any experience of it at all. That was a failing of the pupillage structure of that set, I suspect, but one that we don't repeat where I am now. But at the beginning of my second 6, I started with Tirtha Gupta KC, who is a master here, and almost the first task that he set up for me was on a case that he was doing involving the abduction of 3 children to Pakistan. They were in Pakistan, they were missing there. There was litigation in England, there was litigation in Islamabad, and somebody was needed to go to Islamabad to coordinate between the Pakistani and English lawyers. And who better to do that than a fresh-faced second 6 pupil who had no idea about international family law at all. So I was sent off to Islamabad, where I spent a month, sometimes cowering, sometimes not, in the Marriott in Islamabad, going to the High Court there, coordinating with lawyers in what was sometimes quite literally a baptism of fire into international family law. But I also had, because when I was there, it was, and this is probably long before most of your time, but it was just at the time when they were about to overthrow Musharraf. And so the army was on the streets in Islamabad, there were roadblocks everywhere, and I was too scared most of the time to leave the hotel. So I had a lot of time to read up on what international family law encompassed, and I discovered that it was a point of intersection between the human side of family law that I found so interesting, and which was why I wanted to go into that field, and occasionally very technical international rules and instruments. Mostly, I now understand, and at the time had no idea about, are derived from a private international law context, and they're a sort of attempt to force the ever-changing, developing, evolving life of a family into a strict set of international law rules in a way that often is spectacularly unsuccessful, but at the very least brings about some very, very interesting legal problems that I've had the considerable good fortune to be able to litigate in various different ways. So how did it come that I moved from the terrified pupil in Islamabad to here? I was very lucky because of the set that I was in. I was lucky because there were a number of, a relatively small, proportionately small number, but a number of barristers in that set who specialised in international family law, who were willing and wanted to bring on pupils into that area. But I also went out of my way, insofar as at that stage it's really possible to do that, to make sure that I was available to pick up returns in international cases, to help out with work, particularly in cases, because this is or was at that time often the way that it would have to be done to bring interesting cases on in family law because of the restrictions on public funding sometimes that we experience in pro bono cases. And through that, I had a lot of exposure to solicitors that specialise in that sort of work, and in due course was able to build up a practice. But the key to it, I found, really was making sure everyone was aware that that was what I wanted to do, making sure everyone was aware that I was committed to it, and making myself available to do it, because it's very easy, particularly in a general family law set, which that set was, to be pushed down a pathway that the clerks think is most amenable. And sometimes, not always, of course, we all love our clerks, sometimes that is the pathway that they think is going to bring in the most money to chambers. International family law is usually, not exclusively, publicly funded, and so it is not necessarily something that clerks will focus upon, but it is possible, or was possible, to move away from that and forge a particular path with that as a specialism. And through that, I've been able to be involved in, under the broad heading of international family law, all sorts of different cases involving all sorts of different people. International child abduction and jurisdictional disputes, as has been mentioned, being probably the bulk of them, but international family law also encompasses, for example, forced marriage, honour-based violence, female genital mutilation, issues with jurisdiction for international divorce, international adoption. It is a very varied and mixed subject matter on which you can spend, as I've now discovered, almost an entire career. Preparation for getting into that area, I found, as I've already mentioned, really to be really the biggest stumbling block, because the information just wasn't there for me at that particular point in time. The general courses that I went through, family law, public family law at university, were focused on public law care proceedings and private law disputes that arise in a domestic way. Understandably so, because they form the bulk of the work of family courts in this jurisdiction. But it really meant that I wasn't able to find out anything about this. And I suppose that is one of the reasons to offer a plug too late, because you're already all now here. But that's one of the reasons why sessions like this can be so important. There are also, and this is something that my own failing I didn't find out enough about, but all sorts of ways to experience the broader work that chambers do through mini pupillage schemes and so on and so forth, which was something I came to relatively late. But all in all, if family law is something that you consider you're interested in, I found particularly international family law to be, albeit you might say I would say this, the most interesting way of engaging in that practice, because sometimes, not all the time, domestic family law can be focused on one thing and one thing only, appropriately so, the welfare of the child and the evidence needed to bring that to light, but without a focus on what, without any disrespect to my colleagues at the family bar, sometimes we call proper law. And international family law involves that and involves it in spades, and that's why I've always found it so rewarding. Thank you very much.
Thank you very much, Michael. So we're keeping questions for the end. I would now invite Josh to tell us a little bit about his career and his path to where he is now.
I'm currently a barrister at 9 BR Chambers, which is in South Square in Gray's Inn, and I have a mixed practice in the domestic criminal courts, where I practice or I defend trials in the Crown Court, appeal in the extradition courts at Westminster Magistrates Court, and in the High Court for extradition appeals. And also in international criminal law, where I'm currently instructed by individuals, NGOs, corporates and governments to appear and advise in multiple fora now, including international criminal tribunals such as the International Criminal Court, but also as support to local counsel in domestic proceedings which engage issues of international criminal law with respect to the implications of international criminal law and international humanitarian law on international investment law arbitration proceedings, and as well as before the UN human rights bodies. And my path to that practice and to this practice was, I have to say, entirely unforeseen when I graduated and when I was at your stage. I studied for a history degree with a focus on British imperialism and colonialism in South Asia. I was interested in international relations and international public policy when at school and at university, but didn't foresee making a step to working at the UN war crimes tribunals that were just being established and entrenched at that time. So when I graduated, I got experience in Westminster think tanks. I worked for a public affairs PR agency for a year with a view to potentially working in political communications, which actually bears some similarity ultimately to the practice of international criminal law in some ways, but quickly decided that a career in Westminster wasn't for me. And ultimately I took a training contract at Herbert Smith to get experience as a city solicitor and really to keep my options open. I developed an interest in public international law when studying for the GDL, and always had at the back of my mind when I was applying to do the training contract and studying to become a solicitor that transferring to the bar was an option for somebody with that background. But I was scared actually at that time that with a 2-1 degree in history, that I wouldn't be eligible or I wouldn't be at the top of the queue for the IN scholarships, and the pupillage would be difficult to obtain as a non-law with 2-1. So I didn't back myself to get a pupillage or get the funding that I would have needed to train as a barrister at that time. So I went down the solicitor route. And whilst at Herbert Smith, I sought to give expression to my interest in public international law and human rights law by doing seats in the arbitration group at Herbert Smith and by performing pro bono work for an NGO called Advocates for International Development, who is actually working with the IN now and have gone from strength to strength over the 15 or so years that they've existed. And after qualifying as a solicitor, I was practicing at that stage in the disputes group in Hong Kong, and I thought to myself, what is the most interesting thing that I can do with this qualification? Because I was looking at my options and looking maybe at returning to London to work for a firm. But I'd spent some time in Cambodia, and I'd experienced, or I'd learnt about the establishment of the Khmer Rouge Tribunal in Cambodia. And that visit to Cambodia had a profound impact on me, and I applied speculatively to the tribunal for an internship to see if I could get a job in the defense office in Cambodia, and got offered a job as an intern on the one of the defense teams at the Khmer Rouge Tribunal. Having got that experience, it was a big contrast from big law, but the lawyer that I was working for had an opportunity, also had a case in The Hague, and I was able to be hired ultimately to work on that case in The Hague. And when that case concluded, I went back to Cambodia, and the lawyer was a US public defender turned international criminal defense lawyer. Said to me, what you need to do in order to really make a career of this is to transfer to the bar. because by transferring to the bar, you will obtain the full complement of skills as a trial lawyer. As a solicitor, you will be constrained by not having the full suite of litigation and advocacy experience. So I came back and I applied for pupillage. Fortuitously, I also got a job working for an excellent firm of solicitors, BCL, who'd been instructed to provide litigation support to 9BR, who were instructed in the Kenyatta case. So I worked on the Kenyatta case and had some decent experience in ICL after that. So that was how I got into the practice area. But it was only through going and applying for pupillage once I got back to England and going through the process of trial after trial, cross-examination after cross-examination, oral application after oral application in the magistrates' courts, in small trials in the Crown Court, that I was, after some years, able to develop my skills, which I'm still working on every day, and by no means am yet the finished article in this respect in any regard. But I began to understand some of the nuances of trial advocacy, which you don't quite get the same touch for as a junior lawyer on a big team in a big case at one of the international tribunals, or as a junior lawyer as a junior lawyer as part of a big team at one of the big firms. So the work I do now in international criminal law is pretty different to the work that I started with. It's mainly the result of the fact that I'm practicing from London as a jurisdiction rather than The Hague, but also the practice of international criminal law has changed a great deal since 2010. In 2010, you had the International Criminal Tribunal for the former Yugoslavia, you had the International Criminal Court, the Rwanda Court, the Sierra Leone Court, all up and running. Now, the picture is less active. The world is waiting to see if there will be a slew of prosecutions arising from the conflict in Ukraine. But it has to be said that progress at the International Criminal Court, for a number of reasons, remains slow. And defense practice, at least in part, has somewhat shifted from the art of trial advocacy to work on the pre-trial and investigation stage of cases and situations before the International Criminal Court. So that means that London lawyers doing this work are in part doing more work on preliminary examinations at the ICC, more work on investigations at the ICC than they were doing in the past, and the trial work is done by fewer lawyers in The Hague. I've been asked to give some comments on why or what I find most interesting and rewarding and challenging about this work. International criminal law is a stage in which litigants, defendants and prosecutors seek to develop narratives which shape history. And as a history student in the past and as a history student now, to be part of that process, not simply in an academic way, but in a very practical and real way, is something that I find constantly challenging and rewarding. So if I had any tips for you guys as you're starting out, it would be do as I say, don't do as I did. Because I was extremely fortunate to experience a set of circumstances that enabled me to get into a position to get started in international criminal law. But my advice to you would be to get trained and qualified as barristers now. Do those hard yards at the junior end of the criminal bar and develop your experience deviling and as a junior to pick up work from more senior barristers at that stage before looking outward towards the international criminal bar. I think that's my time up. So if anyone has any questions, I'd be happy to pick them up in the Q&A.
Thank you very much. And as you've noted, good timing as well. Naina.
Evening, everyone. I came to the bar in 2005. I have a practice which I guess I would simplify into 4 areas, and I think the international aspect cuts across all of those. Public with human rights in it, EU competition and trade, which now includes WTO law, some sanctions work, commercial, and across all of those 3 areas, there is an international element. And I'm going to focus on the human rights aspect for this evening. Tell you a little bit about why I wanted to do this work, a little bit about how I developed practice in the area, and then give you just a couple of examples of cases, one at the international level and one at the domestic level, both of which involve human rights, international human rights. I think the question, why are you interested in law, is probably one that I've been asked more times than I can now count on my fingers, starting with those forms you have to fill out for university. But I think my interest stemmed from a very early interest in why some countries are rich and other countries are poor. I remember a very early trip to India where there were children a similar age to me, 8 or 9, wandering the streets with no shoes. And apparently I asked my mother why this was, and I just wouldn't let it drop for the whole trip. And that developed into an interest into how law can be used to help some societies develop, and why other societies might have failed because of problems with their constitutional settlement or corruption issues or governance problems. And so this interest in international development and law then grew into what's the role of law in international affairs, how do states relate to each other, and then crucially, how do individuals take on a state? Which is obviously what's made stark by international human rights law. How did I develop practice in this area? I suppose because the interest was very broad initially. I read PPE. I went up to read law and I changed to PPE after 6 weeks, deciding that I wanted to read Rousseau and do philosophy and economics now, and I would come back to law later. So I did the conversion course after that. And I then still wasn't quite ready to do the BBC. So I went off to Harvard to do a 2-year master's, and I took a lot of courses in international human rights law, public international law, international trade law at the law school. And I carried on with sort of development affairs at the Kennedy School. And I then very much had a similar chain of thought to Joshua. I thought, well, I could go off and be a sort of policy bod in international affairs now, but it's still the law that really interests me. What's the most useful thing I could do now? And pupillage seemed to me the only way that you were going to get a chance to really get to grips with these skills as a lawyer. Cross-examination, how do you confront a witness and extract the inconsistencies in their testimony? How do you make submissions to a judge? How do you organize a trial? How do you learn rules of procedure? Because wherever you go in the world later to opine on their legal system or try and participate in a case that emanates from their jurisdiction and has gone up to a higher level court, I guess you have to have some understanding of how all these bits of every legal system work in your jurisdiction at a minimum, to be able to then look at what's going on in another jurisdiction and have a view either positive or critical about how it's working. And you also need to have that understanding to be able to then fit the domestic bit of the jigsaw into the international, because every case that comes to the international arena has had a domestic backstory in whatever country. So I think similar to Joshua, that's what led me to then really decide I'm going to just get to grips with a jurisdiction and really learn it well. I then completed early years of practice where I took on a whole range of practice areas, but in this area I did some cases involving the Iraq and Afghanistan conflicts, which were what was going on when I was coming out of pupillage, the Guantanamo Bay litigation, and then got involved with the Bar Human Rights Committee and some other organizations like Advocates for International Development, and through that started to do training abroad in different jurisdictions. I also joined the pro bono panel for the UN High Commissioner for Refugees, who intervenes in a number of cases in this jurisdiction to explain to the court what the UN's position is on a particular immigration or asylum issue. I then latterly took some time out from practice to work in a think tank that was doing more of this education and training work, the Bingham Center, and got involved in things like constitutional options in Libya, free speech in Bahrain, writing a new rule of law strategy for what was the Department for International Development, and and I suppose diverted into the sort of policy area a little bit before, I suppose, ultimately deciding, no, I really, really want to focus on law and how you put the law together to solve some of these problems. And latterly, give you a couple of examples of the sorts of cases that I've been involved in. Kieron mentioned Ukraine against Russia. That's obviously a very pure example of an international human rights law case at the regional level in Strasbourg, which involves a wide range of violations that are alleged since February of last year. It is an example of the large team that previous speakers have spoken about. There are sort of over 10 juniors, 2 silks, obviously marshalling a huge number of facts over a very long period of time, basically putting together a live chronology, gathering a huge amount of factual material to evidence matters, and then having this rather strange situation where the jurisdiction of the court is actually changing in real time. You will have seen that Russia left the Council of Europe last year. So very strange setup where your sort of legal parameters are changing as the case develops. And then on the flip side, a case in the domestic arena, I was involved 2 years ago now in a case that involved an oil spillage in the Mediterranean from a big tanker. And a judgment was obtained in Spain against the insurers and involved the captain of the ship. And that judgment was then due to be registered here. And you need to go to court to make an application to register a foreign judgment. And in the course of an appeal against the registration of that judgment, one of the issues that was thrown up was the underlying Spanish judgment obtained in breach of international human rights law. So this court had to consider issues under the international, well, both the ECHR and the International Covenant on Civil and Political Rights, particularly fair trial rights, and to look at how the entire Spanish trial process had unfolded, and then to decide these issues as to the compatibility of the judgment in England with those human rights principles. So I suppose that's an example of how there are different ways you can get involved in international human rights law. You might be on the international stage in regional courts or international courts, or you might actually never leave the jurisdiction, but you might be dealing with the issues in the domestic courts because they frequently now do arise in tribunals, in the High Court and the higher courts in lots of different ways. A consequence of the world shrinking, I suppose, and the norms that we all hold dear becoming perhaps more common and more easily litigatable. Why do I find this work interesting and rewarding, and what do I find most challenging about it to finish? I suppose international human rights law really is, it is the individual taking on the state. I took my daughter to see a Jack and the Beanstalk yesterday. They called it Jack and the Giant. And I you know, often when you are acting for an appellant, an applicant or a claimant against a state, it is the purest expression of trying to vindicate the rights of an individual against a state apparatus. And that obviously is rewarding, but you won't always be acting for the individual. You will sometimes, by virtue of the cab rank rule, be working for the alleged oppressor. You work for a wide range of clients, international organizations, states, companies, and individuals. I find that very interesting because you might think that, you know, the politics of a situation is quite clear, but you can very frequently then learn more about the other sides of the story and the perspectives of others to realize that it's much more intractable, or that the answers are much less obvious than perhaps first appeared to you. You learn a huge amount about different jurisdictions, different legal systems, different ways that you can do procedure. You learn about civil systems, you learn and how they contrast with common law systems, the pros and cons of those. You see in action, you know, the pros and cons of those unfolding. And you spend a lot of time thinking about the difference between law and politics and how far law can get you, and where does politics take over. And you often have to reflect that in your strategy for a case. What do I find most challenging? I think I listened to Michael, I think with some envy, that he has a practice area that maybe appears, at least, I'm sure it's not, but it sounds as though it's sort of focused on one area, and he must be a real expert on international child rights and abduction and so on. I think sometimes it's challenging to be spread across lots of different areas. But I think also sometimes when you're working in an area like international human rights law at the domestic level, where perhaps there isn't enough work to simply do that, it's a reality. And I think that's also an advantage to be across a certain number of areas where you can see commonalities, because then sometimes you can find it advantageous to draw different things from some practice areas into your, for example, human rights practice area. There was a case called, this is the last note I'll finish on, there was a case called Binyam Mohammed some years ago, a famous Guantanamo Bay detainee, which obviously involved human rights. But what was novel about the case at the time, in the brainwave of colleagues of mine in chambers, was that the device for extracting these critical documents from the lawyers at Guantanamo Bay was something called a Norwich Pharmacal Order, which is actually a commercial tool commonly used in commercial cases for disclosure. And I think the practitioners in that case, having that breadth, were able to see the application of a sort of rule of procedure that is not normally used in human rights cases as they're traditionally known, to great effect. So it's a challenge to be spread across lots of different areas, but it can be a real benefit.
Great, thank you very much. We're going to move on to Judy.
Hi everyone. I'm sort of an arbitration specialist, but it's not the only thing I do. So to give you an idea, alongside arbitration, I do a bit of commercial banking, civil fraud, ESG litigation. And at the moment, what's keeping me busy, to give you an idea of how I spend my day, is on the ESG piece, I'm counsel to an NGO which has just filed a derivative action against the directors of an oil company in connection with their energy transition and climate change strategy. So that's a company law claim, but it's got an ESG angle to it, obviously. I'm also representing an FX trader who's suing his former brokerage over Islamic finance swap agreements, so a very sort of black letter banking dispute. And the rest of my time is spent dealing with an arbitration between an American client against a Chinese state-owned entity over a copper mine in the Congo. So it's a real pick and mix. I think that's the beauty of commercial practice, and also I think all of our practices, it sounds like. With every case, you sort of go from 0 to 60 real quick with whatever the dispute is about. So I've always been drawn to these, big business commercial questions, and for me, the past couple of months have been about reading, very stressful climate change reports. But also before that, it was learning about copper mining. I now know more about solvent copper extraction than I ever thought I wanted to know. Before that, there was a wind turbine dispute in Africa, gambling in Greece, and an airline in India. So it's a real it's a real mix, and it suits my personality because I get bored otherwise. But I'm here to talk about arbitration, so that's what I'll focus on now. The beauty, I think, of being an English barrister is that English law is sort of the language of international commerce. So when you have an American party and a Chinese party who want to do business in the Congo, they tend to choose, more often than not, an English law contract, and they tend to also choose for that dispute to go to international arbitration rather than to court for lots of reasons. And there's a lot going for arbitration, obviously. It's supposed to be confidential, you play a role in picking your panel, it's meant to be cheaper, it's meant to be a more bespoke procedure. Alas, I think some of those points just out of practice don't tend to bear out, but it's got a lot going for it. And it tends to be, a very popular choice for lots of parties. There are parties that, institutions that, as a matter of principle, won't go to arbitration, banks being a very good example, depending on what the dispute is. But for international disputes, I think, my experience anyway, is that the interesting cross-border disputes are going to arbitration. So it's certainly an interesting area, and not something to ignore if you're minded to go into commercial practice. Now, what do we mean by arbitration? I edit the arbitration volume of Paul's brief, so I can assure you there is proper arbitration law. But it is an umbrella term for all sorts of wacky and wonderful things. It's basically everything from not being in court and not being in mediation or some sort of facilitated settlement negotiation, and covers sort of everything in between. So I've been in arbitrations where it feels exactly like you're in the English commercial court. It's English law, the panel is retired judges or barristers, everybody basically, it's sort of like adopting the CPR as your procedural order number one or whatever. But it's very similar, and it's basically like being a commercial litigator. Then I've got cases which are kind of a messy melange of, comparative law hell. So I've got one case at the moment where the parties are Bulgarian and Russian. The counsel on both sides are me, English solicitors, American lawyers, Bulgarian counsel, and the arbitrators are Russian, Swedish, and German, and it's an SEC Stockholm arbitration, so procedural law is Swedish, and it's an English law contract, which is the only reason I'm there. But it's a real joyous mess, and I think that's sort of that's kind of what I love about arbitration. It's sort of what people hate about arbitration, but for me, what I tend to like about it. You can't really take very much for granted. That's the first point. And the second point is you also have to be aware of what it is you actually are taking for granted and what you're assuming just coming from your jurisdiction and being trained in the traditions that you and all of your colleagues have been, what it is that you're assuming will be true for you and also your opponent. So I have a story that I think I have time for, which to me is sort of like the quintessential international arbitration story. So I was in a case a couple of months ago where my leader and I were giving, it was an English law dispute, so we made the legal submissions, but our instructing solicitors were American, New York trial lawyers, so they handled a lot of the cross-examination, and the panel was all English judges and barristers. And the partner said to me before she went in, is there anything, that I think I need to know in terms of style as a New York litigator that I should be aware of before I go in? And I thought, I think you're probably fine, because this is an experienced tribunal. They've seen all sorts of wacky things, like, it's probably going to be okay. And she starts, and the first thing you realize, which completely, which I hadn't thought of, is that the pace of it is very different in the States. So, the witness is there. It's a serious fraud case. So, everyone's supposed to be at the edge of your seats. And I assume that she would go in there and shout at somebody like, you see in Law and Order or whatever. But the pace of it is super different. And the reason I realize is because they have a rule of foundation. So you have to set up the factual predicate, the preliminary fact of every question you're going to ask. So it's, did you send this email? Yes. What's the time of the email? Well, the timestamp's there, etc., etc. And the chairman interrupted at one stage and said, you're going to just ask the witness these questions, about things we can all read. It's not going to be a very productive use of time. And for the partner, it was sort of, what do you mean I have to ask these questions? So it was sort of a nice moment, I think, and sort of lost in translation. And then, the cross-examination continued. As I say, it was a fraud case, and we finally got to the juicy, important document. And she's put the document there. The witness is sort of dancing around it. It's very clear what he's done, but she doesn't, she sort of doesn't quite say it. And the chairman says, if you're going to allege that this witness was complicit in the dastardly deed, you better put it to him. And as English practitioners, we know what he means. It's the rule in Brown and Dunn, which is that you have to put the allegation to the witness. And she sort of looks at him and says, what do you mean? And then we had a break, we talked about it, and I said, you have to sort of put it, you have to just say to him, you forged this document, didn't you? And she said, well, why would I do that? He's just going to say no. And I'm just going to give him a platform for explaining why he didn't do it. She said, I know, but that's just sort of, I guess that's just how we do it. And I just didn't realise that that was sort of an English-centric or Commonwealth-centric rule that wasn't adopted across the board. So I think part of being an international arbitration person is you come across these things which make you not question, but it's sort of an interesting reflection on our traditions, which you carry over into your practice in other areas. Disclosure and privilege are another really big issue. So when you have American clients and they want discovery, You know, I want all your devices. Can we do depositions, all this stuff? And then you have civilian lawyers who are like, what's discovery? Why do we need this? I mean, it works, obviously. Arbitration isn't a total procedural jungle, but I think because it's supposed to be a consensual process, and tribunals trust parties to come to their own arrangements, there's a lot more procedural, I call it kind of procedural chess playing to be had, and you have to think about the procedure in a much more creative way than you do probably in domestic litigation when things are much more established. Right, so that's arbitration. How did I get here in the last 30 seconds? I trained as a solicitor, as has been mentioned. So I went to study law, did my LLM, went to the Law Commission, joined a firm called Freshfields, and then went to a firm called Skadden. And the unifying theme throughout all of that was that I think I always suspected that I wanted to be an advocate. So I was drawn to arbitration, not because of a sort of love for private international law, but because as a solicitor, it was a very good way of getting your arbitration legs in. And I would say that in all that time, it never actually occurred to me to become a barrister because I never thought that it was open to me, because I had never seen like a foreign woman be a barrister in London. So I mean, I didn't really, I think I had a very set view of what I thought the English bar was going to be like, and I just assumed that wasn't available. And if I knew any better then, or I knew then what I know now, then I wouldn't have let that stop me. So I think that covers my brief.
Thank you very much. Tom's now going to talk to us about the Pegasus Scholarship.
So I'm a member of Blackstone Chambers, but I'm here wearing a Pegasus Scholarship hat. I'm predominantly a commercial lawyer, and I do a lot of civil fraud, media and arbitration work, and most of my international work falls in the first and last of those areas, and I suspect that's one of the reasons why the in their wisdom decided to put me on the Pegasus Scholarship Trust. I mean, I arrived in Chambers thinking that I wanted to be a public lawyer, but I became gripped by commercial law, and I love the urgency, the complexity, and the cut and thrust and the strategy. I know that those at the other end of the table will say they get that too, but I think, as Judy's explained, that is something that is front and centre of a practice as a commercial barrister. I mean, I had pupil supervisors who specialised in obtaining worldwide freezing orders, search orders, and I thought that's what I wanted to do, mainly domestic. They also acted for musicians, and I thought I wanted to do a bit of that too. But actually, before I'd come to the bar, I'd worked a lot abroad. I'd worked in New York, I'd worked in Mexico, I'd worked in Germany, and I'd worked in Hong Kong. And then at university, I'd studied history, but like Josh, had specialised in South Asia and African history. And I was lucky enough at the end of my first year of tenancy to get a Pegasus Scholarship. And I applied because I thought I wanted a break from my tedious solicitors who'd instructed me for the first year of practice. I thought I want to try and get something different. And Pegasus provided a perfect opportunity to escape from having to go to Bodmin County Court on a Thursday afternoon and then be in Norwich on the Friday. Instead, I went to Bermuda and I went to Delaware. And they were the best of times and the worst of times. Bermuda was really fun. I had a really good time. I was working for an excellent firm then called Appleby, Sperling and Kemp, now Appleby. They're one of the leading offshore firms, and I had a great time learning from a really good, experienced Bermudian solicitor, barrister, advocate, just all-round great human being. And I had a really good time, and it felt like being a pupil again, but without any of the stress, because he didn't need to like me enough to take me on as a partner at all. Similarly, I then went to Delaware, and Delaware, well, before, actually on Bermuda, I was doing high-profile insurance work, really difficult, with teams of English barristers coming out to work there. Very similar to English law, and if you practice in Bermuda, you practice in Cayman, you practice in BVI, what you do in the English court is very similar to what you end up doing in those courts. I then went to Delaware and spent 3 months in Delaware with 3 different old school Wilmington firms. So you were wearing seersucker suits. It was hot. It was hot, steamy work. And I was seeing lots of different types of cases. I was seeing stuff in the employment courts. I was seeing stuff in the criminal courts. I was talking to judges. And as Judy has said, any thought of being able to export what you have learned as an English barrister to certainly that bit of Delaware was just ludicrous. I'd go along and I'd have read the papers in advance. I'd talk to the lawyers on my side. I'd hear what the judge said. I'd often talk to the lawyers on the other side because everyone got on really well. And I'd say, well, the answer is obviously X. And all of them would laugh at me and say, no, the answer is obviously Y. And the answer was always Y. Because actually the way in which things that you think are incredibly familiar, you think consideration is one thing, you think that intention to create legal relations is one thing, but often through the lens of the American perspective, you get to a very different place. So I came away from that thinking, I can't just look at black letter law as being black letter law, because actually there's always a degree of nuance. There's always a degree of difference between the way in which you look at the black letter law, or you look at the case law, or you look at the authorities, or you look at what academics say. And so for my practice, I use that all the time. I mean, I do cases involving international law in the English courts, commercial cases. So I've done cases about Djibouti, I've done cases about the Cayman Islands, I've done cases about Dubai, whole of the different cases. But I've taken what I learned from my time on the Pegasus Scholarship into my practice. Now, the Pegasus Scholarship is an absolutely brilliant institution. It was set up in 1987 by Lord Gough, and its aim is to allow junior barristers to travel abroad and for junior lawyers from other countries to come here to learn about each other's legal systems. So it's administered by the Inner Temple, but open to tenants or employed barristers from each of the inns of up to 5 years practice. And the scholarships usually start in July. They last for 3 months, but arrangements can be changed according to fit the particular requirements both of the host firm and of the individual who's going out there. And in terms of where scholarships are available, people have gone in the past to Australia, Bermuda, Dubai, the European Court of Human Rights, Hong Kong, India, New Zealand, Singapore, Uganda, and the US. And bursaries are made available, and you can also try and make arrangements on your own to go to a particular place or a particular firm that you want to go to, and the trust will consider whether or not to give you a bursary for that. So just by way of example of where are people going this year, in 2023, the trust is offering scholarships to Bermuda, lovely place to go, great shorts, great weather, great swimming, great beaches, and a great firm. So they're offering a Pegasus Scholarship with Kerry Olsen, one of the best known commercial offshore firms. Dubai, time being split between a firm and the DIFC courts. Strasbourg with the court. India, to be arranged depending on what your interests are. So the trust will try and facilitate, if you're interested in criminal work, they'll try and facilitate a scholarship with a criminal firm or with the criminal judges. New Zealand, a long-standing relationship with New Zealand, where the Crown Office arranges for people to go. Sometimes you work for government, but sometimes you can go into private placements. Uganda this year, so the High Court and the Supreme Court of Uganda are offering one scholarship to someone to go and see how those courts work, and absolutely fascinating. And the US, the trust is offering scholarships to Washington, DC and to New York. So if you're interested in international practice and you're lucky enough to be a tenant, it seems to me that you should be thinking about going to the Pegasus, because actually it's just a brilliant way to experience another country. It's a brilliant way to experience another legal system. You see how another legal system is working, and it will give you insights into how you work as a lawyer and how other lawyers work within their own system. But for me, it's been important. It gave me a break from solicitors I didn't like, and it gave me access to a whole new world. And that's what I enjoy doing as a practitioner now. Thank you.
Well, all I can say is Bodmin County Court, you had it easy. I got sent to Newcastle County Court at 3 p.m. hearing on Christmas Eve, which was very difficult to get back from, at least without having to go through the big market where everyone seemed to have lost their clothes. Anyway, leave my junior practice to one side. We're now in a position where we can have a series of questions from members of the audience. There is a good practical question online as well that's been posted. So Jenny's here with the mic. I'm going to open up the floor, and I hope that we'll have some engaging questions. There's a gentleman with his hand up in the middle.
Do I need a mic or?
Just shout.
Yeah. Well, I'm from India. I've worked in the United Nations International Law Commission as the youngest member, and I'm doing my master's in an orthopedic scholarship. I've got a book coming out in 6 months, and includes chapters from Blackstone, Chambers, and Judy. My applications have failed everywhere. I have absolutely no answers to why or what went wrong. At least in my humble opinion, my CV has the extracurriculars and everything to fit the bill for all these things we've spoken about. Is it because I'm an Indian passport holder? That's because my applications have been hindered, or is there any other possible reason that I should consider if I choose to apply again?
Gosh. So, I mean, as it happens, Tom and I have spent a long time sitting on pupillage committees, both in Blackstone and in other chambers. You are fully English qualified as a lawyer?
Yes, I am a barrister in India, of course, but of course I'm not a barrister here because I'm taking exams here. Right.
Do you not need to qualify over here first, having taken a conversion course or something?
No, I still have I've applied for the pupillage,
I see.
but I haven't gotten any confirmation from any of the set of chambers, and
Well, can I suggest we have a quick word with you afterwards, because I'm not sure that's quite on scope in terms of the overall structure of the talk this evening. But I would like to know a little bit more about your personal circumstances, and then perhaps one or two of us can give you some advice about things you might like to do with your application and what typically chambers are looking for here. But that's probably more productive use of the time.
yes, I agree.
Any other questions? Several.
Thank you. I had a question for Judy. So as you had said this in your speech, that you considered yourself a foreign woman, and in all the events that I have attended, I've been told the same thing. So what are the obstacles that you had faced as a foreign woman in qualifying or as practicing as a barrister here, and how have you overcome this?
I can tell you what the challenges have been. I don't know whether I've overcome all of them, but I think that, well, I think it's true not just of being foreign, but just generally. I think that before I came to the bar, I sort of assumed that, you know, you go to court, you stand up, you say the magic words that you learned at Harrow or whatever, and if you don't say the magic words, you don't get the order, and that's just the way it is. And it's not like that, obviously. I saw that I had the wrong impression about the bar as a solicitor, but even since I've moved to the bar, we'll give you an example. I served briefly as a judicial assistant in the High Court, and that is a brilliant place, you know, even if you're not sitting as a JA, but to just go and watch the applications and see the amount of people getting up and doing and making submissions. You see very quickly that it's not just you know, people who are foreign or not foreign, but also the diversity in the way that people do things. So there's no one way of making an effective submission. There's no such thing as the magic words you get, you know, you have to use to get the order. It's just a matter of being persuasive. And I think that for me, in terms of overcoming the obstacle, if that's the right phrase to use, it's more about realizing that I personally find the bar a really meritocratic place, and if you're effective as an advocate, then it doesn't really matter how you go about doing it. You know,
Can I add to that, which is I totally echo what Judy says about the bar being one of the purest forms of meritocracy. You know, in this area, international relations, international law, there are obviously lots of organisations you can work for. There are lots of governments you can work for. There are a myriad other things that involve not working as a self-employed individual. Over the last 20 years, I've done a lot of those, and I constantly am struck by the difference of the bar. And the fact that it is not a large organisation where who your boss might be, can determine your trajectory. That it's not a question of having to constantly pander and suck up and, you know, jostle for recognition and so on. It really is, I think, probably the purest form of meritocracy that I have encountered anywhere. And that, quite apart from what type of law you're doing, or which jurisdictions which courts you're working in, is a huge attraction, selling point, and certainly something that makes me get out of bed every day and want to keep doing this job. I'm not obviously foreign in the sense that I was born here, but I obviously have a background from other places, and I can count on one hand, I think, the number of times that I've felt it a sort of truly sort of difficult obstacle. Maybe I'm lucky, but I do think it is one of the purest places where if you work hard, you do a lot of the things that Michael has said about making sure you're available at short notice if it's something in an area you want to do, being available for pro bono work, telling everyone that this is an area of law that you want to do more of. Please, you know, send me a brief if you have one and you need help with it. That you can chart your own path.
We had a question here in the second row and then the question in the first row.
Good evening. My question's regarding international law and particularly individuals against the state. Have you ever come across issues of enforceability, particularly against larger, more powerful states who might view the rule of law differently?
I think that was actually the last bullet on my talk about challenges. The fact that there is a place where law ends and politics begins. I mean, I think when you're talking about the international arena and you're talking about whether it's the ICJ or any other international court or tribunal, and we do still live in a world which is dominated by states, and states are sovereign, and ultimately it will be up to a state what it does in response to a judgment. And that, I think, is if one of the reasons you want to do this job is to change the world and you're still dewy-eyed about it, I guess that is a sobering reminder.
I think it was Antonio Casese who said that international criminal justice or the international criminal tribunals are like a giant with no arms and legs, because the enforcement of the tribunal's decisions has always been, save for the Security Council-backed tribunals, the biggest obstacle to their success.
But against that, I would say that it's not, you know, sometimes maybe you didn't get the enforcement, you know, the sort of big ticket outcome that you wanted. Some of it's in the journey. I took a year out to work in Afghanistan. I wasn't doing UK litigation. I was trying to rebuild their legal system in Helmand in the south of the country. And, you know, what happened when Kabul fell, was it last year, the year before now, was a really damning indictment of how I spent a decade of my life going back and forth to that country. But there have been some positives. There were some positives when I was there, and there were some positives since, which is that often the people you're working with when you're working in another jurisdiction, the foreign lawyers, the individuals that you might be helping to bring a class action, whoever it might be, I think sometimes the big successes are in the interactions and in the relationships that are forged across jurisdictions. You might have foreign lawyers that you keep up with, that you share ideas with, that you go to when you have a problem. Or it might simply be that you've been useful in teaching people when they have legal problems in their jurisdiction, what they do. Maybe they didn't win against the American Human Rights Court, but when they have a problem on their doorstep, they're better equipped to help them or to help others around them. So I suppose it's a bit more nuanced. I would hate to finish on a sort of, you know, the problems, that the intractability of the ultimate enforcement is a reason why you shouldn't do this stuff, because I think it's obviously what the big prize, but it's not the only reason to do the work.
I don't know whether I really need this in the front
You
row.
are quite close.
But maybe it helps people on the live
People
link.
at the back.
I don't know whether you said this and I missed it. If so, I apologise. But is there a specific timeline on which you apply for the Pegasus Trust scholarships? Are they rolling? And could you tell us a little bit about the profile of the sort of candidates who tend to succeed? Because it sounds like something that would be popular with quite a lot of talented young junior tenants.
It's once a year, and interviews are about now. I think it's October that you've got to apply by, and then the interviews are they're earlier in the year, maybe January. Results come out about now. People then go off in July, and people are looking for. We're looking for people who are from all different types of the bar. So people who have got criminal practices apply, people with commercial practices apply, but fewer commercial practices apply than you might otherwise think. In my chambers, for example, I think I was the last person to apply for a Pegasus scholarship, and I did my Pegasus scholarship in 1997.
There's a follow-up question online, Tom, which is, when applying for a Pegasus scholarship, is it likely to be an advantage or disadvantage that you have some experience of international practice or education already?
I suspect having some knowledge and having some experience shows that you're serious about it and that you want to do it, and that you can display why you want to go to the particular jurisdiction. That said, if you're really, really good, you've got a really good practice, and you want to take time off from your really good practice to go and spend some time abroad, I suspect that won't go down too badly either. I think having a reason why you want to do it is going to help your application.
We had another question in the second row.
Thank you. So this question's for Tom. So I think you said at the start of when you were speaking that initially you were interested in public law, but then you switched to commercial law and international commercial law. Do you ever find yourself still practicing sometimes or delving into public law again, or did you just stay focused on international commercial law?
Over time, I have done a number of public law cases. So most recently, I've done quite a lot of public law cases for the Ministry of Justice in relation to prisons, but only latterly domestic prisons. I did some cases involving Iraq where the cases involved prisons abroad, but Ministry of Justice cases about prisons because I'm interested in prisons. But I'm lucky enough to be able to do a little bit, despite really being a commercial practitioner.
We had a question there first, and then there, and then there, I think, in that order, if I clock the hands correctly. Thank you.
Hi everyone. Firstly, I wanted to say I find all of the work that you lot have done very inspiring, and it's so especially all of the human rights is an area that I'm very interested in. I'm aware everyone in this room is at very different levels to me, but I'm currently, I just graduated from biochemistry. I'm doing a conversion course and hoping to do the bar course in September. And I wanted to ask, for someone at my stage, what type of work do you recommend I can get involved in at this stage to help me then in future to practice in these areas that you guys are so doing well in?
I'd recommend maybe reaching out to NGOs, like Advocates for International Development would be one example, but community-based NGOs, if for instance you're interested in international criminal law, and there are particular situation countries that you're particularly interested in, reaching out to NGOs who are active in those situation countries to see if you can get work experience with them, and that's before you even start thinking about mini pupilages and experiences at the bar. But certainly chambers, when we recruit pupils, we look at all relevant experience in the field of criminal law and criminal justice. So if you have experience with a charity, with an NGO, even with a citizens advice bureau or any organization like that, I would say at the GDL stage, that would be, or the immediate post-graduation stage, in addition to mini pupilages, that would be the way I would go.
And then we had some questions down here. While Jenny's moving over with the mic, let me just interject with an online one. The question has come in, how do you secure a pupillage as a foreign qualified lawyer? And I understand, Judy, you've got some experience of this. I mean, I think you still have to do 12 months from recollection.
Yeah, it's the second part of the question,
Oh, I
which
see.
is what if the pupillage is a reduced one for 3 months? So I think the answer is that if you're foreign qualified, or indeed if you have some kind of advocacy experience as a solicitor, the process is that the first step is applying to the BSB to ask whether or not you get any sort of exemption. But of course, there's a difference between being told by the BSB you're exempted and also convincing a set of chambers that you're also exempted. So I was exempted, but I wanted to do a pupillage. And some chambers, mine being one of them, offer something called an intermediate pupillage. So it's a 6-month bespoke arrangement that's just sort of agreed in terms of what you want to see. So yes, exempted by the BSC. Right, so I think it's got to be a chambers by chambers question. Some I know will look at that and think about whether or not they can be more flexible, and others won't because there's a gateway process. It's hard to be generic, I think, beyond that.
I had a 3-month dispensation from the BSB as a transferring solicitor, so it's a similar kind of scenario. And I did take the opportunity of starting my pupillage 3 months late, but it wasn't a good idea, because pupillage is all about doing as much work for as many members of chambers as you possibly can, to get to know as many members of chambers as you possibly can over the course of that period, in order to get the votes necessary to get taken on at the end of your pupillage. And if you've knocked 3 months off your pupillage, you've knocked 3 months of opportunity off to do that. So ultimately, I didn't get taken on in that set of chambers. I did a third 6, so it actually lengthened the whole process. I'm very happy to be at 9BR. 9BR is top chambers for international criminal, which is what I want to do. So the fit ultimately was better for me, but it did lengthen the process in the end.
One further very quick one from an online guest. Harriet Bennett has been patiently waiting to hear our answers to this for some time, so I'm going to interject with this one as well. She asks, how important is it to have knowledge of another language to practice in the field you do? So let's just do a quick straw poll down the line. Do you need French, Michael?
I've managed to get by with a woeful command of any other language, but there are colleagues of mine who benefit greatly from being able to speak other languages with clients. The thing about family law, in common with lots of other areas of law, is that you're dealing with vulnerable people at some of the most difficult times that they will face in their lives. And if you're able to relate to them in a way over and above the usual, that is a massive advantage in terms of your ability to support them. If you have another language and you happen to speak therefore the same language as your client, that can be a way that you can help them, calm them down, relate to them in a different way to, for example, how I would be able to. So it's definitely not a prerequisite, but in some circumstances it can definitely be an advantage, in family law at least.
French is super helpful in international criminal law. It doubles the amount of defence teams, for instance, that you can work on at the ICC, because some are francophone, some are anglophone. And if you can speak the language of the situation country, that would be very helpful for all the reasons that Michael just said.
Sorry, I think I'm in the Michael camp. I have got by with very little, and I probably spend less time in my international cases with actual clients. So search engines and things that you can use these days can help you decipher tricky bits of documents, but it's definitely an advantage if you do have a language.
So I can say, as an EU law practitioner, it's been useful to have French for EU law. What's not so useful is having EU law anymore. Judy.
So I speak Chinese as my first language, and I think the answer is the same, which is it's not essential, but it's opened doors for me in a way which has been very convenient. So when I was it's what Michael has said is true of any commercial client as well. So as a very junior lawyer, I managed to get myself into the rooms where I was the only one doing any speaking to the client, because I was translating and that was the only thing available. But other than that, I mean, I think I mean, unless you're sort of one of these extremely talented people who can do legal submissions in more than one language, I think the reality is that, you know, I once cross-examined someone in Chinese just to like mess with him, but I wouldn't, you know, I think it's challenging to kind of get yourself to the level where you're comfortable enough in a second language to actually be the advocate in that language. So that's necessary, I think.
I normally realise at the end of a big case that I wish I'd learnt the language.
Right, we had a couple more questions from audience members, so we'll go back to sort of non-virtual questioning for a moment.
Thank you. I echo the earlier sentiments about how it's been lovely for your time and to hear about it. Mine's also sort of a big on your question. I'm at a slightly later stage. I'm due to start a criminal pupillage later this year. And you were speaking earlier about taking on case, and obviously you're at a very well-known chambers for international criminal law. If you're not going to chambers like that, but you still have an interest in it, what would be sort of your recommendations at the later than GDL stage for sort of how you can get involved? I know you're speaking about organisations and things like that, pro bono that you can get involved in.
Well, I mean, actually, this talk has been really interesting for me because I've had the idea, you know, you could maybe see if you could set up an internship and then apply for a Pegasus scholarship. That's just an idea that, you know, and I'm sure through the inn you could be connected to barristers who have experience, who are working in The Hague, who know people who are working on defence teams at the moment. So I think that I think the inn is actually a gateway.
Got some more questions here. Delightful to have so many questions. You've all been paying attention.
Hi there. This is a sort of mundane, almost ethics question. Sorry. I'm just curious, how do you stop lines getting blurred as to what you're competent to advise on? Because obviously we're registered here as lawyers in England and Wales. There'll be EU law. We still are covered for that, I'm sure. Public international, I imagine, because it applies everywhere one way or another. But things like being in other jurisdictions, that's always given me a bit of a head scratch. Arbitration, if it's covering if it's in English law, it doesn't matter so much. But have you come across these sorts of issues? And I don't know who wants to answer it, but it's just a thought that's occurred to me.
Well, I'll tell you about the law of Djibouti. So I did a case against the government of Djibouti, and the only person who keeps Djibouti decided cases is the Attorney General of Djibouti. So it was rather difficult for my client to get access to the law of Djibouti, but the law of Djibouti was the applicable law for the particular claim. So I went to see an expert on French law, because the law of Djibouti, I think, mirrors French law until about 1967, and after that it's the law of Djibouti. And so he gave advice on what the law of Djibouti, from his perspective, would be if it was still similar to French law. So there's an example of me having no knowledge of Djiboutian law at all, but using an expert to advise me as to what the law of Djibouti might be. And I think that was all right.
So you're in effect not giving that opinion, but you're getting the opinion and then working from it.
So the English, certainly from the English commercial court's perspective, it looks at foreign law as being a question of fact. And the question of fact is then proved through expert evidence. And the expert evidence comes from the foreign qualified lawyer. What the English courts, certainly the English commercial court, has been struggling with is not having days and days of experts being cross-examined on foreign law. So the English commercial court now expects the parties to consider whether it's possible for me to make submissions on the basis of the relevant texts without having to call the actual lawyer to come along and say what the texts mean. The danger of having the latter approach is that the expert comes along and tells the judge what the foreign court would decide. And that's not what they're meant to do. They're meant just to tell you what the law is, and then you make arguments to the judge as to what the judge should find on the basis of the law as has been explained to him by the relevant experts.
Hello. So this question's for Naina. So do you ever plan on writing a memoir? Because in the future, because obviously Carla Del Ponte wrote a memoir at the end of her career, and she covered topics on Kosovo and other international cross-jurisdictional events. and you mentioned Guantanamo, you mentioned now with Ukraine and Russia, and also Kosovo. Do you ever plan on doing something like that in the future?
I think I'm a long way off having the material that I would consider would merit writing one. But it's a very complimentary suggestion. So thank you.
Naina did give a talk last year on her experience in reconstruction in Helmand, which was fascinating. It may still be available online somewhere if you want to get a back copy. Available in all good bookshops as well in due course. I think.
Again, I don't think I need this, but probably helpful for people. One of the questions I had was, a big part of why I want to be a lawyer is the kind of advocacy. And it's come across from various members of the panel that quite often what you're doing is not actual advocacy. You're going to advise, you're part of a team, you're doing other kind of slightly miscellaneous work. So I wondered whether we could get a rundown the panel of how much advocacy do you actually do, and has that been interesting in other jurisdictions, and that kind of thing.
Right, we'll take then one final question after that, and there's a couple of questions online that we have, and then I think we'll need to call it quits, I'm afraid, because we're running out of time.
Family law is very much court-based. I'm in court most days, I think.
Michael, can I wrap up with a follow-up from online from Layla Mohammed, who asks, are there any significant or differences between domestic UK family law and international family law? In a sense, let's keep it short, what's the biggest difference?
There are differences in family law in all countries. The two biggest differences are, first, in terms of the work that I usually do, the two biggest differences are between jurisdictions that have the child's welfare as the paramount consideration and countries that have different systems of law, particularly Sharia law, that don't, to put it bluntly, and which proceed on the basis of presumptions about who has guardianship responsibility, inevitably fathers, who has custodianship, mothers, and what, in the eyes of that law, terrible things mothers can do that disqualify them as being custodians of children, for example, marrying someone else or being insane. So those are very real difficulties that we face, particularly with the way that international movement can be at the moment. If you have an abduction of a child from Dubai to England, can you send that child back to be dealt with by a legal system that will apply a standard that is very, very different to our own? The second, much shorter, key difference is between common law adversarial systems like ours and other inquisitorial systems that apply a very different approach to deciding disputes about children that, to me, seems to work in most cases very much better than having two people going tooth and nail at each other using lawyers as their attack dogs, which can happen in cases concerning children in this jurisdiction.
Josh, advocacy.
Well, if you include the extradition work, it's daily. If you're working on a ICL trial, it's daily. If you're not working on ICL trial, then even within the context of the written work that you're doing, 50% of it will be advocacy, because you'll be drafting submissions 50% of the time, maybe advising on material for less than 50%, so a lot.
Naina?
If you're just focusing on international human rights law, a lot of it can be paper-based. A lot of the committees, UN committees, they offer paper-based processes, so you won't be doing that much advocacy. If you're a junior, you're unlikely to be on your feet in Strasbourg very often, for example. You're likely to be sitting behind. But if you are doing international human rights stuff insofar as it comes up in domestic cases, then you've got better opportunities for advocacy as you become a more senior junior. I probably, if you average it out across the year, would be in court once a week, a day a week.
Sorry, I should be clear that I included written advocacy in my answer there. If I would say I'd agree with Naina. Once a week if you're practicing extradition on average, and more frequently if you're in an ICL trial, daily if you're in an ICL trial, but less frequently if the trial's in recess or you're not in trial.
Judy, what's your experience?
I think commercial less, which tends to be, I think, the consensus with lots of people. But but it varies so much. I mean, I know you say miscellaneous work. I think you have to do a mix as a junior, to be honest. I mean, you obviously learn a huge amount being on your feet and being the advocate, but also and that's important to do. It's also important that you don't get into, you know, a kind of monster commercial case which runs for a huge amount of time, and it might be, you know, the sexiest case going through the commercial court then, but if you're sort of the third spear carrier to the right in the greatest battle of history, you were like the third spear carrier to the right. So you learn different things, but it's those experiences of being part of a team and watching how much more experienced advocates do things, I think that then let you grow as an advocate when you're doing things on your own. So if I could make a suggestion, I wouldn't focus, you know, too much on just the amount of time you're getting into court, because you have to have a balanced experience, I think.
Can I fold in a uniquely Hong Kong based question for you, which is, what are the opportunities for English qualified barristers in that jurisdiction in the coming years?
Pass on the basis I'm still trying to figure that out.
Okay. I'm sorry, I did try. Tom?
It's very difficult to say, because you can be involved in a 3-month trial, which means that I'm in trial for 3 months, or I can be doing a day a week because I've got some hearings going on. It really does just depend, and it depends where one is doing it. One of the benefits of COVID means that actually it's much easier now to appear in international commercial courts than it was before, because I don't have to travel to the BVI for my hearing on Wednesday. I can sit in my room in chambers and argue for 2 hours in front of the judge. 3-4 years ago, you'd have had to fly out to the BVI for that hearing. And I was involved in a case where I was flying back and forth to the Kern Islands for hearings that lasted 2 or 3 hours. Now, most of those hearings are done online. So you can have an international practice without travel. That may be something that you like, but it may be equally something that you don't like.
And if you're in Hong Kong, you get up at 2 in the morning, put on your robes, and then go back to bed at the end of the hearing. Tom, quick fold in from the online guests. Prison law for Pegasus scholarship. Any reason why you couldn't combine the two?
You might have to look at one of the government-based ones. So the New Zealand one might give you one, but equally, as we were discussing, there are opportunities to be able to find your own thing and go and try and do some prison work for claimants in other jurisdictions. I suspect that might be more difficult to arrange.
I mean, look at reprieve, death penalty work in America.
There was then a final question for the floor. I'm going to make this subject to 2 conditions. One, it's going to be the last question. So the first condition is it's got to be short. And the second condition is it's got to be a good one. So no pressure. Who was the final? You probably don't want to ask it with that caveat. Oh, there is a final question. Excellent.
While Jenny takes the microphone over, I should just say the October date that I said about Pegasus was the opening of the window. The closing of the window is in December. That's certainly on the basis of last year. So it's by the early part of December, the Pegasus scholarship applications need to be made by.
Okay, I sit here as somebody who was called to the bar in '92, and I'm about to rejoin it, having had a lengthy stint in the middle as a solicitor. And I appreciate there's a few people sitting up there addressing the room who've cross-qualified, and there seems to be a bit of a tendency these days to jump backwards and forwards over the fence. Do you think there's any difference in terms of the facilities you've developed as solicitor advocates to the facilities you've developed as barristers? And is there yet an argument for getting rid of the fence completely?
It's a very good question. I'm not going to deal with the question of getting rid of it completely, but I would invite, because that's a bigger topic than International Committee has budget for, metaphorically. But if I could ask those who have done both sides of the fence to comment on what they've gained from being back at the bar.
Well, I transferred to the bar having been a solicitor, and I as a solicitor I worked in big firms, and then I worked at the International Criminal Tribunals on big teams. So I would never in those situations have, like I said in my remarks, got that day-to-day experience on my feet, doing trial after trial after trial, closing speech after closing speech after closing speech, application after application after application, through which you develop a style, you develop a technique in trial advocacy. You start to understand the art and the science of trial advocacy, which I would never have been able to do as the third spear carrier, as Judy put it. So it wasn't really a choice, and I don't think that that's a distinction that's going to go away anytime soon.
Judy.
Well, in international arbitration, it's sort of a permeable membrane. So I started as a solicitor advocate in arbitration, and I was in a firm that never instructed out, or only instructed out only if they really had to. So I think that certainly in arbitration, the lines are blurring much more than perhaps they used to, or they remain in other fields.
Crime, yeah.
The biggest difference I found is that as the solicitor advocate, I was the person during the disclosure, doing the bundle, speaking to the client, prepping the witness, and then at the end of the evening, when the witness has gone to bed and the client has left me alone, then you go in and prepare your submission. So, I mean, it's a different skill, purely in the sense that at the bar, I think you have the luxury of being left alone a lot more and focusing on what you might regard as the real questions that will win the case, and there's a lot less distraction. One of the beauties, I think, of the split profession is that you have a system where the advocate is sort of protected from, not, I say protected like it's bad, but you know, their time is protected in a way which lets them focus, you know, on giving independent advice and being the best advocate they can be, in a way which in other jurisdictions where you don't have a split profession, that doesn't always seem available.
Thank you very much. Well, I'm going to call time on this very interesting session. Thank you, the audience, for turning up both online and in person, particularly in person. It's lovely to be doing events back in person again. Thank you to our illustrious panel for giving up your time and talking us to this evening. We do have future events coming up for the International Committee. Josh is in charge of organising two separate lectures on the 29th of June and the 6th of July on ethics, in particular in the international criminal sphere and before the ICJ. And we would invite you to come and see those if you want to take things further. I think what we've learned today is that you are not fully masters of your own destiny if you want to get into international work, but there are things you can do and steps you can take to try and be the master or mistress of your own destiny going forward and getting into this field if it's something you find interesting. Pro bono work, internships, and the Pegasus Scholarship. Thank you very much.